Yeah, is this Paul? Yeah, is this working? Yeah, I was looking at this law dictionary. It has what's called fitness of parent. In a divorce suit, the court considers carefully the fitness or ability of a parent to take care of a child or children, as well as the welfare of a child or children, before rendering a decision as to future custody. The welfare of the child is the prime consideration, but important the welfare of the child is the prime consideration, but important secondary considerations are the morals of the individual parents and their financial status. It's an interesting concern about what is it the court considers. Then they have what's known as flogging, punishment for a crime consisting of lashing with a whip. This type of punishment has particularly gone out of existence in this country. I had responded to the dissolution of marriage, not really understanding about due process. But let's say you make up a story and you have a spouse put in jail, and you allege that they committed domestic violence or child abuse. And I went through the evaluations. I went through drug and alcohol evaluation, and I hadn't drank or done any drugs for 20 years. And then I went through an evaluation with a guy named Wayne. In fact, I included it, I think, in my response or in one of my OneDrives. Yes. Where it was really up to the spouse that had abducted my sons if she wanted to reconcile, folks. Well, I had called Healthy Families of Clallam County, and I'd said, well, did you get the documentation from the Attorney General's office on Guam that I'd completed the diversion, the 7 hours of parenting classes? Yeah. Because I had thought we should reconcile. In fact, I had contacted numerous marriage counselors. There was a guy named David Ecoff that I had contacted. He'd been a client of mine and seemed like a good counselor, a psychologist or psychiatrist or whatever they call themselves. Yes. And my thought was that we should go to counseling because obviously after 10 years of marriage it had been somewhat of a strain going through a foreclosure and having to live in a homeless shelter. Yeah. But seems like the eyewitness reports of my blind daughter that she said, well, he's gone crazy. Oh. Well, you got here and issued a protection order within 5 days. I was not given any due process. Somebody had made up a story about how I was the most heinous man in history. And then you went through and got all the dissolution of paperwork and the child support paperwork and the parenting plan and all that. 20 days after I had called Healthy Families of Clallam County, they arrested me under the allegation of violating the protection order. Now, I don't necessarily want to beat a dead horse, pooch. But when you continuously obstruct the rights of a father, I don't think the first consideration was the children. I really don't. I think that Judge Rohrer, realizing, well, the male's unclaimed, and I looked at the Washington State website today about the Child Abuse Protection Act or Domestic Violence Protection Act. Yeah. And it actually says that you can have 2 attempts at service, and then you can request of the court to either have court-ordered certified mail or court-ordered publication. Now, the other instructions say that you have to continue attempts of service when issuing a temporary protection order until motioning the court for publication or mailing the notice of the court hearing. Now, it would have been impossible for me to respond to a temporary protection order in 2011. And any spouse that has spent 20 days going through Department of Social and Health Services and Welfare, getting all those forms filled out, and then calling up Officer LaRue alleging domestic violence 20 days before. 20 days before. There was no domestic violence. In fact, Healthy Families of Clallam County had put their information as the contact information because their job, as I understand it, was to reconcile healthy families. Now, when courts don't consider the primary concern, the children, my 5 sons, and what could have been Jessica at that time, my 14-year-old daughter, when Heidi had abducted our sons, when she had bought 7 plane tickets and not told me. I'm a little concerned that I haven't got a response from Child Protective Services or Washington State or the police department or the sheriff's department or the contact information for my sons. Now, this last protection order where the petitioner didn't sign it, I was not given notice or opportunity to be heard. I can't motion the court. There's no jurisdiction for me to motion the court. And the court has taken upon themselves to not enforce the laws of the United States. Now, I'm really somewhat concerned after a couple years of emailing ri.pdf that somebody's so obstructionistic that they think that they're above the law. Now, it should have been when considering a dissolution of marriage that you would not have had a court hearing unless the defendant had been notified of the court hearing. And you would not have had a custody court hearing until I had been given notice and opportunity to be heard. Now, just because you say you attempt 2 attempts when motioning for a temporary protection order so as to get a permanent protection order, yes! It would have required publication in 2011, quite possibly 2012, yeah. 2015 for sure would have required publication.